You know, for decades, industrial relations in India were, well, a pretty tangled knot. Just imagine trying to navigate a system built on separate laws from 1926, 1946, and 1947. It was complicated to say the least. But in 2020, this massive project set out to change all that by rolling everything into a single, unified code. So let's dive in and untangle this thing, the Industrial Relations Code.
All right, here's how we're going to break it all down. First, we'll look at that tangled web of old laws. Then, we'll see what this new unified code is really trying to do. After that, we'll get into the specifics, like the new rules for unions, and then cover the really critical stuff, like strikes and layoffs. And finally, we'll wrap it all up and ask, what does it all really mean?
So, first things first, what was the problem this new code was trying to solve? Well, for almost a century, Indian industry was running on this web of different, often overlapping laws. And as you can imagine, this created endless confusion, making it tough for businesses to comply and, frankly, for workers to even understand their rights.
And this slide really gets to the heart of the change. On the one hand, you had these three major historical acts from totally different eras, creating this messy, sometimes contradictory system. The new code basically takes these three threads and weaves them into one single, hopefully much simpler cord, the Industrial Relations Code of 2020.
That brings us right to our next section. With such a massive consolidation, what was the actual goal here? What did the government really want to accomplish with this brand new unified code? Well, if you look at the text of the bill itself, the purpose is stated pretty clearly. It's, and I'm quoting here, to consolidate and amend the laws relating to trade unions and settlement of industrial disputes. Basically, it's all about bringing everything under one roof to make it clearer and more efficient.
But if we dig a little deeper, the code really has two main goals. On one side, it wants to simplify the whole legal landscape, to attract investment and just make it easier for companies to operate, what people often call ease of doing business. But on the other side, it's also trying to create industrial peace by clearly defining and protecting the rights of both employers and employees. It's really meant to be a balancing act.
Okay, let's move on and see how this actually works in practice. A huge part of this new code deals with trade unions, and it completely redefines how they operate and, maybe most importantly, how they negotiate. The new rules for registering a union are now super specific. You still need at least 7 members to get one started, but here's the big change. The union also has to represent at least 10% of the workers, or 100 workers, whichever number is smaller. This sets a really clear bar for a union's legitimacy.
Now, this new rule immediately brings up a really practical question, right? What happens in a big company where you have several different registered unions? Who actually gets to sit down at the negotiating table with management? The old way could be chaotic with all these competing demands, but the new code has a very, very clear answer.
And that answer all comes down to a single crucial number, 51%. This is the new magic number, the threshold that decides which union gets the official power to negotiate for everyone. It's designed to end the confusion of having multiple competing voices. So here's the bottom line. If one union can prove it has the support of at least 51% of the workers, it becomes the sole negotiating union. No one else. This is meant to completely streamline the whole collective bargaining process, making sure the group that represents a clear majority is the one with the official seat at the table. All right, now for what is often one of the most contentious parts of any labor law, what happens when things go wrong? This next section covers the new rules for strikes, layoffs, and even business closures. And just like with the unions, there's another key number to remember when it comes to industrial action: 60 days. This mandatory notice period is now a cornerstone of the new regulations, and it's meant to be a critical cooling-off period before anyone takes drastic steps.
And this is a really major change. Before, these rules could vary all over the place. Now, under the new code, any strike or lockout at any industrial establishment requires a 60-day advance notice. The whole idea is to give both sides 2 full months to try and resolve the dispute before it explodes into a full-blown work stoppage.
The code also formally defines something called fixed-term employment. Now, this isn't just temp work. It's a very specific category for workers hired on a written contract for a set period of time. And critically, the code also bakes in some key protections for these workers.
So why does having this official definition matter so much? Well, it's all about worker rights. It means fixed-term employees have to get wages and benefits that are comparable to permanent workers doing similar jobs. They also get statutory benefits on a pro rata basis. And importantly, they're eligible for gratuity after just 1 year of service, which was a pretty significant protection.
The code also does a great job of clarifying the difference between a layoff and retrenchment. They might sound similar, but they're completely different. A layoff is temporary, like when a company can't provide work because of shortages and workers get 50% of their basic pay. Retrenchment, on the other hand, is a permanent termination for non-disciplinary reasons, and that requires a full 3 months' notice or pay instead. That's a crucial distinction.
And for retrenchment, there's now a clear 3-step process. First, the employer has to give that 3-month notice or pay. Second, and this is brand new, the employer has to contribute to something called a worker reskilling fund. And third, if a similar job opens back up within a year, they have to offer it to that retrenched worker first.
So what is this worker reskilling fund? Well, it's basically a brand new social safety net. For every single worker they retrench, an employer has to put an amount equal to 15 days of that worker's last wages into this fund. That money is then used to help those retrenched workers get back on their feet and find a new job.
Okay, let's move into our final section and try to bring this all together. We've gone through a lot of the details, but what's the big picture here? What are the most important things to take away from this massive legal overhaul?
So if you remember just a few things from this explainer, let it be these. 3 tangled old laws have become one single code. That 51% majority rule now creates a single negotiating union. A standard 60-day notice for strikes is now the rule for everyone. Fixed-term employment is now a formal category with real protections. And finally, that new reskilling fund provides a safety net for retrenched workers.
And in the end, it all comes back to the code's stated purpose. The ultimate goal, the thing that's written right into the legislation, is to achieve industrial peace in harmony by creating a more cordial relationship between employers and their workers. That's the big dream anyway.
But of course, that leaves us with the final big question. Does rolling dozens of laws into one actually create a simpler system? Or does it just create a whole new set of challenges? The code definitely aims for balance and clarity, but its true impact on millions of workers and thousands of businesses, well, that's a story that's still being written.